Exclusion clauses are contractual terms that seek to limit or exclude liability for certain breaches or issues that may arise during the performance of the contract. These clauses are commonly used in various types of contracts to manage risk and define the extent of each party's responsibilities. An exclusion clause, also known as an exemption or limitation clause, is a provision in a contract that seeks to exclude or limit one party's liability for specific breaches, losses, damages, or issues that may occur during the execution of the contract. Types of exclusion clauses. Exclusion clauses can take various forms, each designed to address particular aspects of liability. 1. Total exclusion clauses. Definition. These clauses seek to completely exclude liability for certain breaches or issues. Example: the seller shall not be liable for any defects in the product after delivery. 2. Limitation clauses. Definition. These clauses limit the extent of liability, often by capping the amount of damages that can be claimed. Example: the contractor's liability for any damages arising from this contract shall not exceed $10,000. 3. Time limitation clauses. Definition. These clauses limit the time period within which a party can bring a claim for breach of contract. Example: any claims arising from this contract must be brought within 6 months of the occurrence of the breach. 4. Third-party exclusion clauses. Definition. These clauses exclude liability for damages or losses caused by third parties. Example: the company shall not be liable for any delays caused by third-party suppliers. Enforceability of exclusion. Clauses. Exclusion clauses must meet certain legal requirements to be enforceable. Courts scrutinize these clauses to ensure fairness and reasonableness. 1. Incorporation. Clear and prominent. The exclusion clause must be clearly and prominently included in the contract. It should be visible and understandable to both parties. Notice to the party. The party relying on the exclusion clause must ensure that the other party is aware of the clause at the time of entering into the contract. 2. Construction and interpretation. Clear language. The clause must be clearly and unambiguously worded. Any ambiguity will be interpreted against the party relying on the exclusion clause, known as the contra proferentem rule. Scope of application. Courts will interpret the scope of the clause based on the precise wording and context of the contract. 3. Reasonableness. Reasonableness. Test. In many jurisdictions, particularly under statutes like the Unfair Contract Terms Act 1977, UK, exclusion clauses are subject to a reasonableness test. Factors considered. When assessing reasonableness, courts may consider factors such as the bargaining power of the parties, the availability of alternatives, whether the clause is a standard term, and whether the clause adequately compensates the affected party. 4. Legality. Statutory restrictions. Some statutes explicitly prohibit certain types of exclusion clauses. For example, liability for personal injury or death caused by negligence cannot be excluded in many jurisdictions. Public policy. Exclusion clauses that contravene public policy will not be enforceable. Key considerations. 1. Negotiation and mutual agreement. Fair negotiation. Exclusion clauses should be the result of fair negotiation between the parties, rather than imposed unilaterally by one party. Mutual agreement. Both parties should fully understand and agree to the terms and implications of the exclusion clause. 2. Drafting clarity, precision in language. The clause should be drafted with precision to avoid any ambiguity or misinterpretation. Specificity. Clearly specify what types of liability are excluded or limited, and under what circumstances. 3. Review and updates. Regular review. Regularly review and update exclusion clauses to ensure they remain compliant with current laws and industry standards. Legal advice. Seek legal advice when drafting or incorporating exclusion clauses to ensure enforceability and compliance. Practical examples. 1. Commercial contracts. Supply agreements. A supplier might include an exclusion clause limiting liability for delays caused by external factors like shipping disruptions. Service agreements. A service provider might restrict liability for indirect or consequential losses arising from their services. 2. Consumer contracts. Sale of goods. Retailers may have clauses excluding liability for defects discovered after a certain period post-delivery, provided the defect was not caused by their negligence. Travel contracts. Travel agencies might limit liability for cancellations or changes to travel itineraries due to circumstances beyond their control.